Good morning. My name is Noelle O Connell and I'm the Executive Director of European Movement Ireland. I would like to extend a very warm welcome to everyone in attendance virtually with us this morning for our webinar with a keynote address and our guest of honour this morning, Karen Banks. We're also live on YouTube, so delighted to welcome those people who are following us on YouTube as well this morning. So we're very fortunate to have our special guest speaker with us this morning, Deputy Director General of the Legal Service, Karen Banks. And I'm aware that we have some new members and some new followers and subscribers. So in that regard, it might be useful if I was just to give a little bit of background information on who we are in European Movement Ireland. So established in 1954, we're Ireland's longest established not-for-profit voluntary membership organisation that has been working for over 65 years to develop the connection between Ireland and Europe. And ultimately, we work to improve debate, engagement and understanding of European issues here in Ireland, and also to act as a conduit on all matters relating to Ireland in European affairs. And our aim and our goal and our mission is to act as that bridge between Ireland, Europe and the EU. And we do that, we work to do that, we campaign ceaselessly to do that through a variety of projects, programmes, campaigns, events, and increasingly over the last number of months, webinars such as these. And today's webinar is one of a multiple series of webinars that we've done since about the middle of March. We held our annual Ireland and the EU Red Sea poll launch with featured RT's Europe editor Tony Connolly and Dr. Katie Hayward from Queen's University. We also held an EU jobs webinar with the Irish member of the European Court of Auditors, Tony Murphy. We had one with Andrew McDougall, Vice President of the European Investment Bank, looking at business and investment support for Irish business through the COVID pandemic. And last week, we were delighted to partner with the European Commission representation in having a webinar with Andreas Schwartz from the European Commission's Directorate General for Budget. So our webinars have become part of a crucial means for us to connect with our audience. And we do hope that you get involved. Support us, join us, follow us, check us out across all the different social media platforms. And for today's webinar, we'd be delighted if you would ask any questions or comments you may have via the Q&A button on your Zoom platform. Alternatively, my colleagues in the comms and social media team will be keeping an eye on any questions or comments that are coming in across our different social media platforms. Before I formally introduce our guest of honour this morning, Karen Banks, I might just outline very briefly, and Karen, feel free to correct me in your keynote marks if I have made any mistakes, but just maybe it's somewhat self-explanatory, but no harm to discuss in general terms a little bit of the role of the legal service of the European Commission. And essentially, it's an internal department of the European Commission, and in essence is the Commission's legal counsel, whose purpose is to provide legal advice and assistance to the Commission and represent the European Commission in court cases. Central, of course, to its role in its operations is the drafting of legislation, and all Commission draft proposals are indeed referred to the legal service to ensure that they comply with EU law and are within the EU's legal competence. And in addition, the legal service represents the Commission in all litigation, legal disputes before national courts and tribunals, with other responsibilities of the service including conducting international negotiations, acting as a guardian of the treaties, and exercising the implementing powers conferred in it by the community legislator or by the treaties themselves. So in that regard, Karen has quite a busy portfolio of responsibilities. And our guest speaker, we're delighted to have her joining us from Brussels this morning, Deputy Director General of said legal service, Karen Banks. She has considerable experience in the European institutions, working with the service on multiple issues, and serving as a member of the social affairs team, the external relations team, business law team, and the AGRI-FISH team. Indeed, from 1995 to 97, Karen served as a member of the cabinet of Mr. Pádraig Flynn, European Commissioner with responsibility for employment, industrial relations and social affairs. And previous to her current position, she served as the director, head of the AGRI-FISH team of the legal service. And Karen has expertise in competition law, social law, intellectual property law, and has published widely on European legal issues, contributed to the European Law Review, the Common Market Law Review, Industrial Law Journal, and various other publications. I think she is, if and I know I'm right on this one, I hope, she's one of the 3 most senior ranked Irish people currently serving in the European Commission. So it's a fantastic opportunity to go behind the scenes with her today and have the opportunity to be in conversation with Karen. So before I hand over to her, in terms of our running order, Karen's going to give some opening remarks in which she'll discuss her work, her career to date. And following that, then there will be an opportunity for Q&A, panel discussion and debate. So please feel free to submit your questions and we will have you all on your way well inside the hour mark. So thank you for joining us. And Karen, many thanks to you, and I'll hand over to your good self. Thank you.
Good morning, everybody. Thank you, Noelle. So I've been asked to give a little intro to my career. I suppose that has to begin with the fact that I was brought up in Dublin and I studied law in UCD before doing the solicitor's exams. I worked for about 1.5 years in a country town as a solicitor, sort of breaking my teeth on fascinating things like registered land transactions and so on, until thinking that my little grey cells might die. I started casting around to see what else I could do. I ended up going to London to do a 1-year master's degree in the LSE, which was extremely interesting. And somewhere along the way, I had sent a letter into the Commission office in Molesworth Street with a CV saying, you know, do you have anything I might be qualified for? And I had got back what I took to be a snubbing response telling me I would be informed of any competition for which I was eligible. I had never heard of competitions. I had no clue what this was about. I took it that I was being put in my box. Anyway, I disappeared off to London, had my fascinating year there. And while I was there, of course, it was beginning to be borne in upon me that I was going to owe the bank rather a lot of money by the end of this year. And in the meantime, the Commission had started sending me copies of official journals, which again, I had never seen in my life, saying, why don't you fill in this form? This seems to be something you might be qualified for. And so in a quite accidental sort of way, by the end of my year in London, I had got through the first part of a competition to join the Commission. And since I then passed the last part of it, the oral part of it, as I say, in this somewhat unplanned manner, I ended up as a very junior member of the Commission legal service. I started out in the competition team, and that was, again, a very odd thing because I had studied subjects. I was very keen on social law. I had done comparative family law, labor law, that kind of thing. And I had no clue about economics. And here I was plunged into a highly economic branch of the law. But it was extremely fascinating and people were very kind in terms of helping me and letting me learn. I must say that's a very nice thing, I think, about the Commission, certainly about the legal service. It's a very kindly environment. If you're curious and willing to learn, there will always be people who will help you to do that. So I had 4 years in that team. Then I moved to the social affairs team, where I took care of various things like labor law and family law, my old favorites. I had finally managed to wriggle my way into my zone. But of course, you're not allowed to stay where you want to. In the legal service, we have a policy of rotation. We think that people should move after a certain amount of time so that they don't become too rigid in a given area and having too strong views on any given subject. So I was then moved to the external relations team, but I didn't stay there for very long because at that point, the cabinet of P. Flynn invited me to join it. And so I did that for 3 years, and that was a very different kind of experience, of course, because rather than thinking, as Noelle has explained, about legal advice to operational departments or how to defend a case before the Court of Justice, I now had to think how to present P. Flynn and his policies how to overcome certain levels of hostility which were sometimes present in women's lobby groups and so on, because I was in charge of the equality dossier. That was my main responsibility in that cabinet. So that was all very, very interesting and different to the work of the legal service. Then I came back to the legal service at the end of those 3 years and carried on, first in the business law team, where Noelle has mentioned that I took care notably of intellectual property matters. And then I moved to the very different team, which was the agriculture and fisheries team, which you might think is a bit of an odd place for a Dublin girl to go. But I had this idea that I had already been quite a number of years in the legal service at that time, and I had never taken care of this core competence, this big central policy area, which was the original area in which the EU had a lot of competence, and that I ought to know something about this at some stage in my career. And I ended up staying there quite a long time, and in fact becoming head of that team, becoming a director in 2011. And then in 2015, I was asked to take on my present job, which is Deputy Director General of the Legal Service, where I have a whole ragbag of responsibilities. The Deputy Director General, as the name suggests, does whatever the Director General doesn't want to do. And so I have all kinds of bits and bobs of responsibilities, but two very, very interesting and important roles. One, coordinating infringement cases against member states. So whenever we think that a member state hasn't fulfilled its legal obligations, I have to take care of the coordination of the legal positions we take there, and also coordinating the positions we take on behalf of the Commission in front of the Court of Justice in cases where there could be borderline questions or where there might really be a doubt as to what position we should take. So that, in a nutshell, is where I have got to and what I do.
Fantastic. Thank you, Karen. Whistle-stop tour, but no, by no means no less impressive all the same. And I was just going to pick up actually on some of the points that you raised. And I think you touched upon it there. In terms of your current role and then previously serving as a member of a cabinet, you know, how is that different, or how would you describe it to those following online?
Okay, well, as a member of the legal service, when a dossier comes on your table, you're looking at it to see what the legal problems are. Are they suggesting we should do something for which the EU is competent? Is the role which is proposed for the Commission a role which the Commission is entitled to occupy according to its institutional place in the framework of EU law? What are the legal pitfalls? What will be the weaknesses? Whereas in a cabinet, it's quite different. You're thinking about the visibility of your commissioner. You're thinking about the policy for which he is responsible from a policy point of view. So the law goes very much into the background. It's there, of course, because you have to take account of it. But my interest as the member of P. Flynn's cabinet responsible for equality was, for instance, to promote and get adopted by the legislator the fourth programme for equal opportunities. My job involved, for instance, going to the group in the Parliament which takes care of women's affairs, to get them on board, to somewhat reduce their tendency to be a bit suspicious of this large conservative Irish politician. They weren't so sure how committed he was to women's equality. So I needed to engage in a very political way in convincing the Women's Committee and convincing lobby groups that whatever they might think of Mr. Flynn, his policies were very much in their interests and they should cooperate with us. It was a question of negotiating with the harder-nosed, more economic part of the Commission, who might have been a bit suspicious or doubtful about social type initiatives, to convince them that these initiatives were also very important as part of our work. So it was very much more a political and a negotiating and a strategic role, rather than thinking about legal issues.
So complementary skill sets, perhaps, to complement the legal background, right?
Certainly, and it helped me a lot because although I enjoyed it, it's obvious that I chose to come back to the legal service. So it also gave me an opportunity to discover that although I could operate in that in that political environment, I really preferred and was more comfortable being a lawyer. That was my real vocation. But when I came back to the legal service, I was tremendously helped by that experience in terms of prioritizing my work. I understood much better what was what, and what was actually going to fly, and what I should bother spending time on, and what I could just put to the bottom of the pile. Prior to that cabinet experience, I would have taken the consultations as they came in strict order of date, and dealt with them in a somewhat automatic manner. I learned not to do that anymore.
Right, fantastic. And I think, Karen, that actually, makes sense in terms of having that broader, rounded experience in a number of different areas that can add value when you go back to the legal service function. So is that something you'd encourage all lawyers, people in the legal profession to consider, perhaps not taking a sabbatical or a gap year, but something additional to complement their legal training and background?
Yeah, I think it's a very good idea. I see amongst my own colleagues who are absolutely great. I have a wonderful group of colleagues, excellent lawyers, very committed, very independent-minded, but sometimes insufficiently aware of the political context in which their work has to be done. And I think it's a very good idea to take time out and go and live in another context and think about other dimensions to issues. It helps you to do your legal work better if you really understand the practical and political context in which it's going to have its impact.
Absolutely. And I mean, I don't know how much you can, but feel free to give us an exclusive or breaking news. But going to the B word, all things Brexit related, I'd be really interested in getting your views, Karen, if it's possible and appropriate, in terms of what it means for Ireland in the legal sense, as the last remaining common law jurisdiction in the European Union with the departure of the UK. Interestingly, it's a question I actually get asked myself quite a lot at conferences and different events, at international panels, more so when people are interested in getting that Irish perspective. Some arguing that Ireland will become more isolated after Brexit as one of only, the two common law jurisdictions remaining in the EU, and others arguing that perhaps this presents an opportunity for Ireland. So I'd love to get your thoughts and your perspectives on that.
Okay, it's interesting how recurring this question is, when I actually don't think it's a very important question. I'll explain why. Of course, it's true that the common law has its specificities, and it's true that with the departure of the UK, Ireland and Malta will remain as the representatives of a common law tradition. But the difference between civil law and common law, I think, is not very determinative in terms of EU law. I mean, the legislator writes law drawing on all traditions and taking what is best or what they find useful out of the ideas coming from all the different traditions of the different member states. So at that level, there's a kind of a mix. And there will be notions coming from common law and notions coming from civil law, and that will continue to be the case. And even more importantly, in the Court of Justice, I would say that the common law tradition has had a vastly disproportionate influence, because the court, in order to build up the EU legal system, in order to create a dynamic and growing and developing system of law, it has very much, I would say, chosen the common law approach, which is that you decide cases in a very practical and pragmatic and strategic way, thinking about the consequences, not at all, never formal, never saying this belongs in category X and therefore the answer is Y, always saying, taking what we call a teleological approach. What could have been the intentions? What will be the consequences? If I decide it this way, how will that work out in other cases? And so on. I mean, I would call that a very pragmatic, practical, and I think typically common law approach. So it seems to me that the court has very much bought into the common law approach, and that has become so much embedded in its way of reasoning and working that is very unlikely to change. So I actually don't have this sense of threat at all that I hear quite often from practitioners of the common law.
No, that's really interesting, Karen, and actually I think very, very comforting, and something I obviously, if I can credit you, I might be guided by your sentiments there. So when I get asked any of these tricky questions again,
send them to me.
I'll send them to you, exactly. I'll refer to my esteemed colleague, Karen Banks, on it. No, that's brilliant. Some of the Q&A, Karen, coming in, and fantastic to see that. And our good friend, the French ambassador to Ireland, Stéphane Crouzat, bienvenue Stéphane, has asked a very interesting question just in terms of Karlsruhe and the ruling by the German Constitutional Court. And another question has come in as well on that. And I know it's been described as striking significant blows to the very heart of European integration, its common courtesy, and the primacy of EU law. What's your take on the Karlsruhe decision?
Well, of course, it was seen in Brussels as a very great blow. I mean, the German Constitutional Court has for some years been insisting that it was entitled to make sure that the European Union did not exceed its competences, because it feels the responsibility, which is understandable for a constitutional court, to protect the constitution for which it is responsible. And it wanted to make sure that there were not undue incursions by EU law beyond where EU law was entitled to go. And so far, as long as a constitutional court realizes that it needs to participate in two legal systems, the constitutional system for which it is primarily responsible, but also the EU system to which its member state has committed, and operates in such a way as to try to reconcile the two in a very cooperative and what one might call good faith manner, then I think things can work. But here, for the first time, the German Constitutional Court really utilized the weapon which it had been sort of talking about and caressing, so to speak, for some years, in a really unfortunate case, where it basically had asked the Court of Justice about the legality of the ECB's bond buying program. It got the answer from the court, and it basically discarded it. It discarded what the Court of Justice had said. It refused the authority of the Court of Justice, and that is really very, very grave, not only in terms of the primacy of EU law, and in terms of the ability of the Court of Justice to guide and to help the courts of all the member states to develop EU law and to apply it in an equal way across all member states, but also in terms of the message it sent, because what did the German Constitutional Court say? It basically said that the bond buying program of the ECB was potentially illegal. It didn't go so far as to say that it was definitely illegal. It gave the ECB still a chance, 3 months, if I remember correctly, in which to better motivate and better justify the so-called proportionality of its bond buying program. But it did that in such a way as to undermine the independence of the ECB, because it indicated that it was the Bundestag, it was German institutions, which had to be satisfied about this justification which the ECB is supposed to produce. So both in terms of the independence of the ECB, which is a very important principle, one, by the way, with which the German government tremendously agrees, and in terms of the primacy of EU law and the ability to ensure that it will be applied as indicated by the Court of Justice in the same way throughout the member states, this is a very grave judgment.
Very grave judgment, and I think one you'll be following closely, watching developments closely, yes.
Certainly.
Well, Karen, a couple of questions have come in actually, and interesting, I think, is something you touched upon yourself in some of your comments. Just what must be done to strengthen compliance with the rule of law in the EU and to ensure that member states who infringe the rule of law are adequately sanctioned. So in terms of democratic backsliding and the sanctions in terms of member states infringing on the rule of law, can you comment on that?
Yeah, we have, of course, in the treaty there is a procedure under Article 7 in which the Commission engages with a member state where we are concerned about issues of rule of law, whether that has to do with judicial independence or freedom of the press, or sometimes independence of other bodies like data control commissioners and so on. And in many, many cases, those engagements, those discussions lead to changes at the national level, because you get a cooperative government and one interested in not being in the bad box, so to speak, in connection with rule of law. And then if that doesn't work, the Commission can recommend to the Council to take action, to make recommendations to the member state. And if you go to the end of that Article 7 procedure, the Council can actually decide to punish the member state by taking away, for instance, voting rights or so on. We have never got to the end of that process, although we have embarked on the first stages of it in relation to Poland. We've never got to the end because, of course, it requires unanimity, and it would be very hard to get unanimity in the Council against any one member state. There are two well-known member states who have more or less sworn to back each other up if ever it comes to a vote. So what can we do given that somewhat blocked position in the rule of law process? Well, what the Commission has tried to do is to identify infringements of the rule of law, which are also infringements of concrete provisions of the treaties. And in relation to Poland, we have brought a number of infringement procedures, always connected with the independence of judges. So there were two which were about the fact that sitting judges had their terms brought prematurely to an end by an alteration in retirement age. So both for the judges of the Supreme Court and for the judges of the ordinary courts, Poland decided that even sitting judges, not just judges who would become judges after the new legislation was brought in, but also sitting judges would cease to be judges at a date earlier than they had expected. As well as that being an interference with their legitimate expectations, the manner in which you could get out of that, so to speak, by applying to have your time as a judge extended, involved having to apply to the Minister for Justice or the President, depending on how high in the judicial pecking order you were. And then there was an undefined period, so an open-ended period, in which your application for your extension would be pending at the political level, and you would be carrying on operating as a judge. So you can imagine the degree of independence which can be expected of someone under those circumstances. So for all those reasons, we brought two different infringement proceedings against Poland, and we won, and Poland changed the rules. So that was good. Now we are engaged in another case, which has to do with the disciplinary rules, which are applied or capable of being applied against Polish judges, because it is possible in Poland for a judge to be disciplined for the actual content of his judgment, not because he has misbehaved by getting drunk in public or dancing on the table, but actually for his judicial work, his or her judicial work. And there are various aspects of the procedure which don't ensure proper rights of defense and so on. So we are in the middle of that. That is a court case which is going on. We got an interim order from the Court of Justice a few months ago, which we are currently discussing with the Polish authorities. The Court of Justice decided that pending the outcome of this court case, Poland should suspend the operation of the disciplinary chamber. That's the chamber of the Supreme Court which hears disciplinary cases. And we are currently discussing with the Polish authorities whether that order has been complied with.
Okay, and actually, Karen, that was very comprehensively answered. Thank you for that. And tying that in, one of our attendees has just asked maybe, and I think you touched upon it, but perhaps you might be able to marry the two questions together, just in terms of beyond the bond buying issue. Do you have a read on the other issues that the German court's decision might affect, to follow on what you touched upon in terms of the Polish judiciary situation, but also in Hungary? And how do you see the German court's decision possibly impacting on those?
Well, the irony of the situation is that, much as one may criticize what the German Constitutional Court did, and I do criticize it, as I think all EU lawyers would, it was very much operating as an independent court, very much. I mean, what the German Constitutional Court has done is not at all in line with German government policy. So it is being very independent. But ironically, what it has done is playing into the hands of rather anti-rule of law tendencies in countries like Poland and Hungary and others, who are now pointing to the judgment of the Bundesverfassungsgericht and saying, you see, it is the Supreme Constitutional Court of a member state which is the ultimate arbiter and which has to decide. And it's very important that we tell the EU to buzz off and not be interfering in our internal affairs. And that is a big problem. What has been done by the Bundesverfassungsgericht was, I dare to say, a little bit naive. It's clear that it's going to be used and misused by those who are very keen on national sovereignty and very keen to push away the idea of the supranational element and controlled by the Court of Justice. It's even being mentioned now in the Brexit context.
And moving on, actually, to the Brexit context, if I may go back to one of your former positions as a member of the AGRI-FISH team with particular responsibilities for fisheries law, do you think, what's your expert view on it? Can compromise be found between the EU and UK on fisheries in terms of the current Brexit talks, which has become such a stumbling block, really?
In fisheries, a compromise can always be found. Traditionally, we have these dreadful quota negotiations that go on all night, some night late in December, coming up to the Christmas holidays, when you know that everyone is going to want to be free and go home. And so at some point, whether it's 2 o'clock or 4 o'clock in the morning, ultimately a compromise is found. So in principle, a negotiation is a negotiation, and you trade things. I give you access to this bit of water and you give me a bit more quota on that stock, and so on. So in principle, agreement can be found. The problem is very much political. The British made such a show of excluding the Europeans from their waters, taking back control of their waters, that they've put themselves in a difficulty to make significant concessions. I'm not involved in those talks now, but my understanding is that they are insisting very much on this idea of zonal attachment, which means that they would like to give the vast preponderance of the fishing rights on any given stock to fishermen from the nearest bit of land. That's the idea of zonal attachment. But you can have that as one of the criteria that you take into account when you divide up the rights over any given stock. But if you have that as your exclusive criterion, then of course you're not going to give very many rights to people coming from further away. So we'll have to see. I mean, yeah, it's all about negotiation and politics. At some point, will the British government be able to convey to its public opinion the idea, yes, well, do you prefer to give no access to stocks to the Europeans, or do you prefer to have no access to the European market for the fish that the British fishermen catch in their waters? At some point, a deal is going to have to be done.
And just actually, Karen, if it just as a matter of interest, is much of your day-to-day role and your current responsibilities, does Brexit feature quite a lot in that, or are you across the different areas that I mentioned in your very impressive bio and resume at the start of the webinar?
Yeah, Brexit, of course, is a constantly recurring theme. But it hasn't to date taken a lot of my time, because we have a member of the legal service who is sort of detached to that work and who goes to all the meetings of the task force and then who comes back and discusses with the Director General, sometimes with me, always with the respective team, depending on what is being discussed. Is it rules of origin? Is it fish? Is it stocks and shares? So it depends on the subject matter. So I am only involved in a general way if some institutional question is being discussed. For instance, if the role of the Court of Justice is being discussed, then I would be involved in that. Okay. Yeah, Brexit is a part of our lives as well over here, Karen. Yes, I can imagine.
Karen, if I may, just coming to the end of some of our questions, as you're aware, and I think it's something that you have very much supported, so thank you for that. You know, you're an inspiration to aspiring Irish graduates, particularly in law, who are interested in following in your footsteps. If I could ask you, what top tips maybe would you share? Because as you know, here in European Movement Ireland, and with credit to colleagues in the European Commission representation, the European Parliament Liaison Office, the Department of Foreign Affairs, EU Jobs, the Perm Rep in Brussels as well, and the Public Appointment Service. There's a big drive as part of the, encouraging Irish graduates to consider working in the different EU institutions. What tips or guidance or advice that could you impart to those who are watching it, given that you're at the top of the tree and one of our flag bearers from an Irish perspective?
That's very kind of you. Well, the first thing, I suppose, is to interest yourself when you're studying in law, and in particular comparative law. Obviously, you should take EU law if you want to have a career in the EU institutions. And if there are courses available allowing you to compare what is done, for instance, in common law systems and civil law systems and so on, that is very, very enriching in terms of future questions that you might have to consider if you did have a job in the EU institutions, and in particular in the legal service of the Commission. But in terms of getting in, the problem is languages. I know, because I have come to Dublin and talked at recruitment seminars and so on, and I can tell that there is plenty of talent, there is plenty of very good legal education out there, there are plenty of very knowledgeable people who would be great colleagues, but they are going to have to survive a day in an assessment center speaking either in French or in German, because that's the way the competition is set up now. This is different to when I was recruited 37 years ago. Because there are so many different languages and so many different nationalities, they've had to very much professionalize the competition. And the result is that once you get past the first written stage, you have to go to what is called an assessment center, and you spend a day there, and you have to perform in a language which is not your own, one of English, French, or German. So for the Irish, in principle, that would be either French or German. And you don't have to be perfect in that language, but you have to be able to talk, because the day consists in game playing, role-playing, exercises. You're given 100 emails and you're meant to read them in 20 minutes and then fill out your diary for the following week. It's all, they're testing your reactive capacities, your negotiating capacities, your ability to react to unexpected situations and so on. And so you need to have a sufficient degree of fluency and confidence to be able to deal with it. It doesn't matter if you make grammatical mistakes, it doesn't matter if you are not perfect, but you have to be able to speak and to speak with some confidence. So getting the language capacities up to that level is the big challenge. And I think you have to be practical. Either you do an exchange with a family, you're lucky enough that your family is able to organize that for you when you're young, or if you graduate and you haven't had any exposure to one of those languages, you need to go and live and work, do something, go as an au pair, teach English as a foreign language, do whatever, but go and plunge yourself into a spoken language environment so that it will just be natural to be able to speak in that language. Because I can't overemphasize, that is really key to getting through the competition now.
Yeah, and that's something that we have seen, Karen, as well ourselves, and I know lots of efforts are ongoing on that, and hopefully we will see a greater support for the primary school foreign languages initiative, and also in a second level and third level. I think it's hugely important. And I know some of the questions have come in just in terms as well, opportunities for Irish lawyer linguists and lawyers with Irish language qualifications as well, because there's huge opportunities there as well.
Absolutely. Absolutely. I know that all the institutions are always looking for Irish speakers all the time, because Irish speakers who have a legal qualification are not that thick on the ground. So if any of you are out there and you want a job, I'm sure you'll be able to get one, either at the Court of Justice or in the Parliament or in the Commission. The jobs are there.
Fantastic. And we in European Movement Ireland would be delighted to help the signposting and assistance that we can give. I know lots of colleagues in other organisations have Irish language officers as well. So if anyone does have any queries and we didn't get a chance to touch upon it today, don't hesitate to drop us an email at info@europeanmovement.ie and we'll be able to do our best to assist with any queries that have come in. Karen, my last question for you, if that's okay, conscious of time, and you've been very generous and forthright with your responses, so thank you very much for that. One of our attendees today has just asked, and interestingly, it's something I didn't think about asking you, so I'm going to take my moderator's privilege and ask, how is lockdown affecting your working day to day and your work, basically? How is that impacting on what you do?
All right, well, that's very interesting. Well, I don't know how much you can all see, but I'm sitting here in my study at home, painting on the wall.
Oh, lovely painting.
Because we are all working from home. Pretty much the whole commission, but certainly the legal service. From the beginning of lockdown, our Director General decided that our work could very well be done from home. And I must say that the technical department of the Commission did a fantastic job in hooking us all up with computers and so on. There was an initial week where the connections were a bit wobbly and so on, but by now we're all set up. And since what we do is very largely responsive, we get consultations coming in, we get texts that we have to look at, we get legal questions to look at. There's a certain amount of printing which has to do, and home printers are not always as good as the office. So sometimes one goes in just to print, and then you bring the stuff home and work away on it at home. Because the Berlaymont at the moment is a rather grim and unwelcoming environment with empty corridors and people going around with masks. It's not all that encouraging, if you like, to be there, and the canteen closed and so on. So yeah, we are all working from home, having meetings by Skype. It's a little bit more difficult. I had a meeting yesterday to discuss a court case where there were about 10 of us trying to discuss. And, you know, it's not so easy when you're trying to think about difficult legal issues and you're trying to watch the little conversation pieces coming up and allowing people to intervene at the right moment and so on.
Tell me about it, Karen.
There are those extra challenges, but I think there are good and bad things. The bad thing is that you don't have a proper division between home and work life. So you're inclined to just stay there in front of the computer for hours and hours. That's not so good. On the other hand, it's quite nice. When I do stop, I trot along to my kitchen and make myself coffee the way I like it. And that's not so bad.
So there's pros and cons, I guess.
Exactly.
It's fantastic.
Exactly.
Fantastic. Well, listen, Karen, thank you so much for joining us this morning. Really, really appreciate your time, your generosity, your knowledge, your insights, and your expertise as well. And it's very reassuring, I think, to know that there's such a competent and capable hand at the tiller in the legal service in the European Commission. So thank you very much for that. If I could just, in drawing proceedings to a conclusion, if I may as well, thank my European Movement Ireland colleagues. We are all, Karen, as well, working remotely and from home and in different counties throughout the country. So again, a big thanks to the EM Ireland team and to all of our members, our stakeholders, those of you who have gotten involved, and particular thanks to those who've raised questions. If we didn't get an opportunity to come to your question, don't hesitate to drop us a line and we will do our very best to get back to you. We've a busy schedule of activities over the next number of weeks. Our next webinar following on from today, we're delighted to be joined by the European Ombudsman, Emily O'Reilly, and that's taking place the 18th of June at 11 a.m. So make sure to register on our website for that, and information will be sent on to you. But if I can today pay particular thanks and appreciation to Karen for taking the time out of her busy day. I hope now you can pop off and have a well-deserved cup of coffee.
I'll do that.
Thank you very much. Thank you. Take care and hope you're all safe and well. Bye-bye.
Thank you for having me. Bye-bye.
Bye-bye.